Petitioner is before this honorable court challenging the order withholding 100% of my lord pension and gratuity.
100% pension.
Yes, my lord.
Number
5.
5. Pension withhold ಮಾಡಿದಾರ.
Yes, my lord. Withholding of 100% pension and forfeiture of 100% gratuity.
Why?
My lord, the petitioner was
Ready? No time. Yes.
please. My lord, the
Cancer patient ಇದನಾ?
please,
Cancer patient ಇದನಾ?
cancer patient.
Writ
That
appeal
division, yes,
entry
yes.
order went in writ appeal.
Yes.
Please, my lords.
Yes sir. Now you should be ready.
ಅವ್ರು ಇನ್ನೂ ಡೆಪಾಸಿಟ್ ಮಾಡಲಿಲ್ಲ ಅಮೌಂಟ್.
ಪರವಾಗಿಲ್ಲ.
Yes.
100% ಕೊಡೋಣ.
Please. My lord, the petitioner was earlier working as a superintendent, my lord, in the office of service tax, my lord. At that time, my lord, a trap was laid and my lord, he was arrested for the said offence for demanding and my lord, collecting a bribe of rupees 1,500. But subsequently, a criminal case
Yes.
was my lord,
Acquitted.
trial was conducted, acquitted. Though it was my lord, I cannot fully say it is a honorable acquittal, but my lord, reasons assigned by the judge there would indicate that prosecution has utterly failed in proving the case. But subsequently, departmental inquiry was conducted on the same set of
Subsequent of simultaneous.
simultaneously. Same set of my lord, allegations and articles of charge were framed, my lord. And thereafter, inquiry officer was appointed. On 2 occasions, the inquiry officer writes that my lord, charges are not proved. But disagreeing to that, my lord, the disciplinary inquiry is conducted. Throughout, my lord, it is held by the commissioner. Then the impugned order is passed by, my lord, the respondent number 2.
Withholding complete pension.
Yes. After seeking, my lord, advice from the UPSC. My first legal ground would be this, my lord, based on my lord's judgment, my lord, that one who hears the inquiry must pass an order.
ಕಳಿಸ್ಬೇಕಾದ್ರೆ.
ಅದಾಗತ್ತೆ. ಅದಕ್ಕೆ ನಾನು, that is not the sole thing I am urging.
One who hears must decide ಅಂದ್ರೆ you will have to send it back.
I just brought it to the, because I cannot avoid that my lord, completely from my line of argument. That is one aspect. So, my first attack is that my lord, on 2 occasions the inquiry officer holds the charges are not, my lord,
No, that's all. The disciplinary authority has a right to disagree.
yes, it has disagreed. Therefore, I have offered my explanation. UPSC suggests, my lord, withholding of 100% pension and forfeiture of 100% gratuity. Against that, my lord, an appeal is preferable before the Ministry of
Finance.
Finance. I have preferred. Till today, my lord, there is no response. I have attended superannuation in 2012. Then suffered cancer, took treatment. Now, my lord, somehow I am alive, but without a pie from the, my lord, my employer. This is my case.
Lords,
ಹೇಳಿ sir.
lords, under the delegated powers, my lords, the respondent.
Mike.
Under the delegated powers, my lords, the respondent number 2 and 3 has conducted the disciplinary proceedings. And on the basis of the UPSC recommendations, my lords, the amount of the 100% of pension and gratuity was withheld. And challenging that order, my lords, the respondent, the petitioner has preferred an appeal before the respondent number 1, finance minister,
ಯಾವಾಗ?
way back in the year 2023, my lords.
23 ಅಲ್ಲ.
Please,
All right. 23 ಯಾಕೆ ಅಷ್ಟು ಲೇಟ್ ಆಗಿ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಾ?
My lords, the order is passed on in the year 23 after the passing
The
of the
impugned
order.
order is dated
23 only. That order is only, my lord.
6 February 2023, my lords. And thereafter, my lords, the appeal was before the respondent number 1, finance minister. And since when the interim order was passed, my lords, the matter has not been taken up for the hearing because of the,
What interim order was passed?
my lords,
50% deposit.
50,
ಅದಕ್ಕೂ
my lords,
appeal-
please,
To
my lords.
pay was the order of
ಅಲ್ಲ,
this honorable.
ಅದಕ್ಕೂ ಅಪೀಲ್ಗೂ ಏನ್ ಸಂಬಂಧ?
My lords, since, my lords, the,
Don't consider the appeal ಅಂತ ಹೇಳಿದ್ವಾ? ಇಲ್ಲ.
no, my lords.
Yes.
My lords, I represent respondent number 2 and 3, my lords. Respondent number,
Respondent. ಅಲ್ಲ,
Appeal is pending before the-
first respondent, leave it.
please, my lords. And thereafter, my lords, this honorable court by the interim order dated, my lords, was pleased to pass an order thereby directing the respondent number 3 to pass an pay the 50% of the pension and gratuity, my lords.
ಕೊಟ್ಟಿಲ್ಲ.
No, my lords, thereafter it was modified, directing the respondent number 2, my lords.
Deposit.
No, my lords, to pay, my lords.
Pay
Challenging both the orders, my lords,
In writ appeal.
please, my lords.
What happened in the writ appeal?
Thereafter, my lords, it was modified to the extent that, my lords, the said amount has to be deposited before this court, my lords.
ಮಾಡಿದ್ದೀರಾ?
No, my lords. Sorry, my lords.
Stop.
Please, my lords. For that reason, my lords,
Stop treating these employees as your
My lords.
chattels. Yes. Anything else? The petitioner is before this court calling in question an order dated 6/2/2023 by which the disciplinary authority imposes a penalty of withholding of 100% pension and 100% gratuity that the petitioner was entitled to on his retirement, on his attaining the age of superannuation. Heard so and so. The facts date back to an incident that takes place on 23/9/2011, by which the Lokayukta conducts lays a trap upon the petitioner and is said to have been caught red-handed receiving a sum of rupees 1,500 rupees. The petitioner was not found to be in of the said 1,500 rupees, but it was recovered from the office table of the petitioner. This led the CBI to institute proceedings registering a crime for offences punishable under section 7, 13(2) and 13(1)(d) of the Prevention of Corruption Act. The CBI, after investigation, filed a charge sheet. The petitioner retires on attaining the age of superannuation in the interregnum on 31/1/2012. Long thereafter, it transpires that the disciplinary authority issues a charge sheet against the petitioner on the very same set of fact that the petitioner was caught allegedly receiving a bribe of rupees 1,500 on 23/9/2011. The concerned court, i.e., the criminal court hearing its order dated 19/3/2015, acquits the petitioner by making several observations. The inquiry officer who was entrusted with the inquiry to inquire into the allegations in the charge sheet so issued on 23/9/2014 holds the petitioner not guilty of the offences. The disciplinary authority is said to have disagreed with the findings of the inquiry officer not once but twice, and on the basis of the advice tendered by the Union Public Service Commission in terms of the extant rules or regulations, withholding of 100% pension and forfeiture of 100% gratuity. Therefore, the petitioner is denied of both pension and gratuity by the same order. On 6/2/2023, the petitioner is said to have preferred an appeal against the order passed by the disciplinary authority aforementioned, aforenoted. The appeal is yet to be decided. The petitioner therefore knocks at the doors of this court in the subject petition on the score that he has retired 14 years ago and his pension 14 years ago, and he has no money to fall back upon, as he has neither pension nor gratuity, the only two benefits that he would get. The learned counsel appearing for the petitioner would vehemently contend that both the criminal case and the departmental inquiry were instituted on the same set of facts. All the evidence that was let in the criminal case were repeated in the departmental inquiry as they were taken up simultaneously. The inquiry officer had correctly held that the charges against the petitioner was not proved. The disciplinary authority twice over disagrees with the finding of the inquiry officer and imposes a penalty that is worse off than dismissal from service. The learned counsel would submit that the petitioner is suffering from cancer and he has no money for his treatment inter alia. The learned counsel appearing for respondent 2 and 3 would refute the submission to contend that merely because the petitioner is acquitted of the crime, it does not mean that the department is precluded from proceeding against the petitioner on by initiating a departmental inquiry. He would submit that the order of the concerned court acquitting the petitioner is on benefit of doubt and not an honorable acquittal. He would contend that the department has conducted an inquiry in accordance with law. The disciplinary authority has power to disagree. Notice was issued on such disagreement, and therefore this court should not interfere with the findings rendered by the disciplinary authority, imposing the aforesaid penalty on the advice of the Union Public Service Commission. Therefore, narrated facts are not in dispute. The link in the chain of events are a matter of record. It would suffice if the issue would commence from the date on which the sleuths, S-L-E-U-T-H-S, sleuths of the Lokayukta lay a trap against the petitioner on 23/9/2011. It is alleged that the petitioner was alleged that an amount of rupees 1,500 was recovered from the office table of the petitioner, and therefore a crime comes to be registered by the CBI. The police then file a charge sheet against the petitioner. In the interregnum, the petitioner retires on attaining the age of superannuation on 21st January 2012. The charge sheet against the petitioner springs 2 years after his retirement in the year 2014. A perusal at the charge sheet is indicative of the fact that it is verbatim similar to what was charged in the criminal case in CC 26 of 2013. As there was no other fact that led to initiation of a departmental inquiry except the fact that the petitioner was laid a trap by the Lokayukta sleuths. The concerned court answering acquits the petitioner of the offences. It becomes germane to notice the order of acquittal notices that the petitioner is acquitted on extending the principle of benefit of doubt. The reasoning rendered by the concerned court is completely otherwise. The concerned court notices that the prosecution has miserably failed to prove the guilt beyond all reasonable doubt, but while so saying, grants the benefit of doubt to the petitioner. Therefore, it is not the order that is to be looked into, but the substance that led to holding that the prosecution has miserably failed to prove the guilt beyond all reasonable doubt. The reasoning so rendered reads as follows. Page. The issue now would be, in the teeth of the acquittal of the petitioner, whether the departmental inquiry, whether the penalty imposed upon in a departmental inquiry should be sustained or otherwise. It is not in dispute that the act of the petitioner allegedly getting involved in an offence under Section 7 gave rise to two proceedings, one on the criminal side and one on the departmental side. Therefore, they are on the same set of facts. A perusal at the charge sheet filed by the CBI and the charge memo so issued against the petitioner are verbatim similar. The witnesses are the same. The documents are the same. If on the basis of those very documents, the petitioner has been acquitted in the criminal case, it becomes hardly justifiable for the respondents to impose a penalty which is worse off than dismissal, as the penalty that is imposed is 100% withholding of pension contrary to the rules and 100% forfeiture of gratuity. The first issue, whether the proceedings on the departmental side could get quashed on account of the acquittal of the petitioner, need not detain this court for long or delve deep into the matter. The judgment. The apex court in the case of Ramlal versus State of Rajasthan, reported in 2024, has held as follows. Quote para 25 to 34. The apex court holds that if the two proceedings spring from the same cause of action, and both the witnesses and the documents that are relied on by the prosecution in both the cases are the same, the court should not shy to quash the proceedings on the departmental side against the said employee. The said finding of the apex court would become completely applicable to the facts of the case at hand. Even before the said judgment rendered by the apex court, a division bench of this court in the case of Ejaz Hussain versus State of Karnataka as follows. The judgment of the division bench was tossed by the Lokayukta before the apex court, and the apex court has dismissed the SLP. In that light, the issue being no longer res integra as to whether the departmental inquiry could be quashed on the aforesaid circumstance of acquittal, I deem it appropriate to hold that the action of imposition of penalty long after the acquittal on the same set of facts is unsustainable and the penalty required to be obliterated. Next para. The penalty that is imposed against the petitioner is 100% withholding of pension. The 100% withholding of pension is not a penalty that can be imposed in terms of the CCS pension rules. It is maximum 50 rupees.
Yes.
It is
Rule
to
14.
maximum 50%. The pension and gratuity both are taken away of an employee who was acquitted long before the imposition of such penalty, driving him to impecuniosity and condemned by penury. Therefore, the action of the respondent cannot but be held to be grossly harsh against the petitioner. Therefore, the petitioner becomes entitled to all the terminal benefits that would flow from the quashment of the order, or the order of penalty being obliterated. It is further to be noticed that that a coordinate bench of this court, in terms of its order dated so and so, had directed payment of 50% of gratuity and 50% of pension owing to the illness of the petitioner, which was malignancy. Ministry of Finance, the first respondent, is said to have tossed tossed the said order before the division bench. The respondents 2 and 3 are said to have tossed the said order before the division bench. The division bench modifies the direction to pay, but directs deposit. Even the deposit of 50% as directed is not made even as on date. This is an admitted fact. Therefore, the order of this court is treated casually by the respondents 2 and 3. In that light, the petitioner becomes becomes entitled to penalty other than interest kashta, becomes entitled to all the benefits that he is in due of. In the for the aforesaid reasons, the following order allowed, quashed. The petitioner is entitled to all consequential benefits that would flow from the order. The consequential benefits would mean the entire pension that is withheld and the gratuity that is forfeited to its full to be paid to the petitioner within 8 weeks, within 4 weeks from the date of receipt of the
8 weeks.
no, 4 weeks from the date of receipt of the copy of the order. In the event the respondent 2 and 3 would not disperse the aforesaid amount, the petitioner becomes entitled to interest at 6% per annum from the date it fell due, i.e. the date of superannuation, till the date of its payment. In the event the respondents would not pay the said amount, conditions are 6%. It is needless to observe that the pension of the petitioner would be paid and not drive a septuagenarian to this court again. Yes.
The appeal is pending before the respondent number 1, my lords. To that effect,
Yes.
That may be observed by,
that may be observed, my lords,
it
because
becomes in first place
thereafter-
in view of this order.
Sir,
Thereafter, my
will the
lords.
appellate authority override this court's order?
Definitely.
I'm not, my lords, that is not the submission, my lords, but
On Parahaki, the learned counsel for the respondent submits.
please, my lords. The court may observe, my lords.
No, one nimisha adalla. Learned counsel for the
fact.
respondent submits that an appeal against the said order of the disciplinary authority is pending consideration. Despite that, I deem it appropriate to pass the order that I am now, pass the order in the teeth of the fact that the petitioner is 73 years old and is suffering from cancer, and would not drive him back to this court on the order of the appellate authority being against him, yet again. Yes.
In some circumstances, my lords, our advice is also not considered.
Correct.
There are certain.
You have
things, my
left
lords.
him, you have left him bleeding, sir.
Please, my lords.
ಅದು penalty ಅಂತ interest impose ಮಾಡ್ಲಿಲ್ಲ. ಇಲ್ದಾದ್ರೆ I would have.
My lords,
ಅದಕ್ಕೆ ಹೇಳಿದ್ನಲ್ಲ, you can't treat your employees as your possessions.
Please,
Chattel ಅಲ್ಲ. They are human beings.
my lords, even we also.
ಅಲ್ಲ, ನಿಮ್ ಬಗ್ಗೆ. Sorry.
The department peoples, my lords.
Yes.
Some of the officials at the higher.
This is very harsh.
Please, my lords.
Absolutely harsh.